Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
All right, folks. Welcome to the show. It is the Laura Owens saga. In this case, it is her parents' bankruptcy saga. This, for you who are completely new to the case, Jan and Laura Owens, mother and daughter, have dried Ronn Owens dry. This legend in radio broadcast back in the day, who made a fortune doing it. Now he's clean out. Now, are they without means? Absolutely not. Ronn and Jan Owens have a combined over $21,000 a month in pension and social security. So how they managed to get bankrupt? Well, they have to fund their daughter's spending somehow. And Jan Owens likes to spend money as well. So millions gone. And now Ronn Owens is over 80, has Parkinson's, and is about to lose the home. But he could have put a stop to this years ago and didn't. So this is the bankruptcy case. This is the second time the Owens have filed for bankruptcy. And so we have listened to, we have read through documents, we listened to other hearings. This here is the final hearing in this bankruptcy saga. And the trustee attorney for the feds, Miss Giaimo, is not holding back. Not holding back at all. Thank you, Bruce. 6 euros. Yay! Thank you so much. Yeah, if you're on mobile, you can support this channel with euros. And I think that's amazing. Other ways to support this channel is via PayPal, via Buy Me a Coffee, or the regular Super Chat, gifted membership, stuff like that. Yeah, but we are here for the bankruptcy hearing. So I will put myself here, and thank you to Schnitzel Ninja for uploading the audio from the hearing. Yes, this is audio only. So everybody go subscribe to Schnitzel Ninja after the show.
Schnitzel Ninja.
Hearing case 26-05144, Elizabeth Naylor and Ronald Owens.
Good afternoon. I'll take the appearances in the Owens and Naylor matter. Let's start first in the courtroom.
Thank you. Good afternoon, Your Honor. Jennifer Giaimo on behalf of the U.S. Trustee.
Thank you. Good afternoon. And I'll take appearances from Mr. Owens and Ms. Naylor.
Yes, good afternoon, Your Honor. I am Elizabeth Ann Naylor, appearing pro se.
And I am Ronald Stephen Owens, also participating pro se.
Okay, thank you. Good afternoon.
Sure.
All right, let's go ahead and get started. We've got two matters on calendar. This is the time set for continued Chapter 11 status conference, as well as a hearing on the debtor's motion to dismiss this voluntary Chapter 11 case.
Yeah. Once this is what they tried. Well, they tried to voluntarily dismiss this Chapter 11 bankruptcy after it became apparent that neither the court or the trustee trusted their word. They wanted documentation, they wanted bank records, they wanted everything. And they tried to dismiss it, probably in order to refile it again. That didn't work as planned. And thank you, Marilyn, for 10 euros. Thank you so much. 10 euros was a gold coin. Yay! Thank you to Princess Chelsea. 200 euros. Yeah, man. Yeah. Thank you. I am still not entirely sure what the monetary value is of the jewels, but I do know that those I didn't have 5 minutes ago. So, me personally, I'm grateful. Let's continue.
I'm aware of the parties' filings, but let me turn it over to you to see how we wish to proceed. Shall I start with you, Ms. Giaimo?
Thank you, Your Honor. Yes, so just to remind Your Honor, the debtors had filed a motion to dismiss, and at the last hearing at which that was raised, Your Honor wisely pointed out that we needed to collect some documents and do more investigating before the case should be dismissed. I'm very glad that Your Honor had required that. We did receive what was called an accounting of the GoFundMe funds, and we received many bank statements that I was able to review. As the U.S. trustee laid out in her recent supplemental response to the motion to dismiss, there was some disturbing material that came out through our investigation. And for that reason, the U.S. trustee's position is that there's definitely bad faith here and the case should be either converted or dismissed. And also, as laid out in our supplemental response, we think that based on our analysis of the assets, that dismissal with a 2-year bar to refiling would be the wiser choice because there does not appear to be really any sure collectible assets in this case.
Right. Thank you.
Well, the collectible assets is the house. The house is valued at around $1.5 million. They are currently in debt, I believe, for over 2.3 million, if not more. And reminder here, that these two make collectively over $21,000 per month in pension and social security. On top of that, they had a GoFundMe going, which collected over $130,000. All gone. And some of the thing it went to was Jan Owens' Macy's credit card debt for, I believe, $18,000. $100,000 on one credit card. So yeah, not a good look when the GoFundMe is all about Ron Owens' medical condition and medical needs to spend it on Macy's.
I did have an opportunity to review your supplemental response at docket number 89. Tell me more about why the recommendation is for a 2-year bar to refiling. Often we use a shorter period if there's a secured creditor looking to foreclose, or a longer period if we're looking for litigation to conclude. 2 years is pretty lengthy, so could you give me some additional information about that long period? And also, it's my understanding that Ms. Naylor and Mr. Owens have agreed to that period. Is that correct?
Yes, Your Honor. Yes, I should have pointed that out. Yes, Ms. Naylor and Mr. Owens, in correspondence with me, have indicated that they were willing to have the case dismissed with a 2-year bar to refiling. So the reason that we're asking...
Yeah, that kind of surprised me that they are volunteering to it. I believe they are volunteering to not take the case further, because trying to fight this might pique additional interest from the feds, asking, all this income, where did it all go? And where are the taxes for it, for example?
For 2 years is because this case was filed in bad faith, we need to have a sufficient deterrent to prevent another repeat filing that would, again, interrupt creditors from pursuing their rights. 2 years, just weighing it, seems like an adequate amount of time to allow a foreclosure of the home to follow through if that's what's going to happen. I understand that there was a foreclosure set first in May, then I think it was reset to September.
Yeah, when they first filed for bankruptcy last year, here's the deal. They could have sold the home. Say they sold it for 1.5, 1.6. Yeah, they would still be, at that point in time, they were $2.1 million in debt, leaving them with $500,000 to $600,000 in debt. But they still make $21,000 a month. They could easily have rented an amazing condo in an assisted living type of thing for $5,000 a month. They could have then had $5,000 to spend on themselves a month and still paid off $10,000 a month, making them debt-free in 4 years. Not many people going into bankruptcy court have the means Ron and Jan Owens have. They could live amazingly. But Jan Owens and Laura Owens don't want to live well. They want to live in luxury. And we found out in the interview they had with Trustee Attorney Giaimo that Ron Owens has a life insurance. Again, he's over 80, has Parkinson's. Sadly, usually that means he has not long. My assumption here, based on how I believe Laura and Jan Owens, how they are just waiting for him to die to collect the probably millions in life insurance. And I will assume it will be gone within 2 years. That's my assumption. But they don't care. Now, before that, Laura Owens might be in prison. And I don't think Jan Owens will she can handle spending those money by herself, ending up, because I believe Jan Owens is in her 60s. I would assume if Ron doesn't live much longer, she will be homeless within 5 years.
November now, I believe it's reset to November. Ms. Naylor would know that information better. I don't know what is going on with that process, but it seems to me that that is the driving force behind these bankruptcies is the house, right? So I think that we absolutely need to give the creditor sufficient time to foreclose on the house if that's what's going to happen. I think 1 year might not necessarily do it, especially if they're trying to work something out. And so I feel like it's actually to the benefit of the debtors to have it be 2 years. So
Wait, did you just say it would be to the benefit of the debtors to be 2 years?
well, yeah, because maybe that gives because if there's that much leeway given to the mortgagee to foreclose on the property, maybe they'll be a little bit more willing to spend some time trying to work something out with them.
Oh, I see. So should the mortgage company have additional time during which Ms. Naylor and Mr. Owens cannot file bankruptcy, they may be willing to enter into negotiations during that elongated period.
Right, exactly.
I understand. Thank you.
So there's that. And also there were 2 lawsuits against the debtors that those can proceed. And I think that based on the information that we discovered and laid out in our supplemental response, there are potential claims, I believe, by GoFundMe Inc. or donors. We definitely need to make sure that there's sufficient amount of time to allow those parties to pursue any rights if they choose. I mean, I have no involvement in that, but just based on my own investigation. So I think 2 years gives an adequate amount of time and is proportionate to the bad faith that we've seen here. And it gives an adequate amount of time to allow creditors to pursue their rights in state court, which is really what we want, right? That's the best interest of the creditors. And yet it doesn't completely foreclose the debtors from refiling should the need arise later, but there's a sufficient buffer with a 2-year bar so that creditors won't be harmed yet again.
Okay. Thank you for explaining that. One reason I had asked is just because there was the pending foreclosure sale. The court previously declined to extend the stay.
Yes.
And so it seemed that the mortgage company could move forward. Plus, under Arizona statutes, they could foreclose within 90 days anyway. So it just seemed like a long period. I hadn't really considered the idea that a longer period would actually motivate the mortgage company to engage in negotiations. Have you seen that happen before?
No, but I don't know why the mortgagee is continuing to move out the foreclosure date. So I'm assuming that they're working with them. That's all. I really don't know. I mean, I've tried to reach out to them and they've not really been very responsive to me, to the banks. So, that's just one factor, but I do believe that we should have sufficient time to allow creditors, not just the creditors that were listed in the schedule, but other potential claimants that I mentioned in our supplemental response to pursue claims against these debtors without a bad faith bankruptcy filing.
Okay. Another area of inquiry, and you did address it in your supplemental response, was just whether conversion would yield any distribution. I read what you wrote, and I certainly appreciate that trustees are loath to have cases where we have animals that need care and food, et cetera. It ends up costing them money as opposed to yielding benefits for creditors. So I certainly understand the reasoning of the U.S. trustee there. Is there anything else you want to tell me, not necessarily specifically with animals, but any of the other assets and the opportunities for recovery?
Yeah, the animals they're talking about are horses. There's one pony out on lease for a year. Don't know how much time left of that, but apparently they have additional retired horses as well under their care, which is interesting. Surely there are people in and around Arizona for a symbolic amount of money would take care of retired horses. I'm sure there are. Because these people, the Owens, in my opinion, should not be allowed to spend money on horses when they owe $2.3 million or more. Yeah, as Dave says, I can guarantee those horses are liabilities, not assets, except for a very select few. They are a hole in the pasture that you throw money into. Yeah. There's a joke here. How do you become a millionaire by owning horses? You start out as a multi-millionaire.
Well, Your Honor, I should mention to you that while the case was in a Chapter 13, there was a short time during which these debtors' case overlapped with the filing of a Chapter 7 case by the debtor's daughter, Laura Owens. And the attorney representing the Chapter 7 trustee in the Laura Owens case was Terry Dake. And I know that he was very actively looking into potential assets. And if you recall, there are some businesses that are co-owned by the daughter and either Miss Naylor alone or Miss Naylor and Mr. Owens with the daughter. And I did reach out to him to ask him what his professional opinion was as to whether the preferences made to the daughters is something that he looked into, and whether there was any assets that he could conceive of, either in the Chapter 13 case or in the Chapter 7. And it was his opinion, just to me, in an informal discussion about it, that this did not seem like a good case for conversion. So we did factor that in. I didn't put it in the pleadings because it wasn't a real formal discussion. It was just something that I had run by him because of his familiarity with the case. But I did agree with his assessment based on my own analysis of all of the assets that are disclosed.
Okay, thank you for that additional information. And I do recall a prior hearing you had mentioned Mr. Dake was involved in this case in some respect. So now I understand it's with the debtor's daughter.
Yes.
Okay.
Yes.
All right. What else do you want to tell me?
Your Honor, I think we just pretty much laid it out there. We think that there's definitely concerns, but in light of the financial situation, conversion would not make sense. It would be really a burden, I think, to any Chapter 7 trustee to ask them to take on such a case. So I do think that dismissal with a 2-year bar is the only way to handle it because of the bad faith. I do think there was a lot of bad faith, and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations. And I would ask that that's what Your Honor do, especially in light of the fact that the debtors are agreeable to the 2-year bar.
Yeah. Let's listen to that again. Now, Miss Giaimo, I believe it's Miss or Mrs., I don't know, Queen Giaimo has been a bankruptcy attorney for the U.S. government for over 20 years. With that in mind,
and that because of that, that's why we should have a little bit of a longer bar on refiling, because this is one of the worst I've seen in terms of misstatements, misrepresentations. And I would ask that that's what Your Honor do, especially.
One of the worst she has ever seen bankruptcy cases regarding misinformation and misrepresentation. That speaks volumes, because there's a lot of bankruptcies that are not in good faith. And this one here is one of the worst, according to Trustee Attorney Giaimo.
In light of the fact that the debtors are agreeable to the 2-year bar.
All right. Thank you, Ms. Giaimo.
Thank you.
All right. I note that there are a number of individuals who are appearing by Zoom. I'm wondering if there's anyone present who wishes to be heard before I return to Ms. Naylor and Mr. Owens. All right, hearing no one speak, I'm going to go ahead and turn to you, Ms. Naylor and Mr. Owens. What do you want to advise the court at this time?
That we have reviewed the trustee's supplemental response. We agree with the final recommendation to dismiss the case with a 2-year bar, but we would like to state respectfully for the record that we dispute any insinuation of any sort of fraudulent intent or bad faith. As pro se debtors, the Chapter 11 reporting rules were very complex for us, and any omissions or anything like that were honest, unintentional mistakes that were.
Oh, bullshit. We did a stream here when we listened to when Jan tried to gaslight Miss Giaimo, who didn't let her gaslight. And most importantly, when Jan believed the recording was off, she kind of apologized to Giaimo regarding her statement, because Jan said, well, we had to play for the people listening in. No, Jan, you lied over and over and over and over again. You made statements in this bankruptcy case and your prior Chapter 13 bankruptcy case that cannot simultaneously be true. It's impossible. You lied again. And now, on the final hearing, you keep lying.
Due to our lack of counsel, and we feel we cooperated fully and provided anything, any of the bank statements for 18 months, anything that we could to ensure total transparency.
Okay, so tell me about the 2-year bar date refiling. What is your position with respect? It was represented in the record that there was a stipulation and agreement to that period.
We had informal discussions with regard to that, and we had told the trustee that we were willing to go with a 2-year bar. I mean, frankly, we hope we are never, ever, ever in this situation again. And as we had explained before, we are trying to explore what options would be available for us to modify the mortgage and to come to agreements with the other creditors to resolve this outside of bankruptcy.
Okay. Are you engaging with your mortgage company or others in terms of in an effort to resolve those outstanding claims?
Yes, and we had, well, as far as the mortgage is concerned, we very much appreciated your suggestion that we work through the, I believe it's the MMM program through the bankruptcy court. And when we explored that, it appears that that would only come into play while we were actively in bankruptcy, and that once the case would be dismissed, that entire process would go away. So we have been trying to work through correspondence with the mortgage company, and we have again been told that in response to our latest communication with them, our latest letter with them, with the latest correspondence, that they will respond to us within 30 days. So perhaps that's why they may.
That would be standard replies. Send us what you think, and we will reply to it within 30 days. I highly doubt the mortgage company have interest in working with people who first remortgaged their house with the help of their daughter Sarah and then stopped paying and hasn't paid their mortgage, I believe, in almost a year. I highly doubt the mortgage company have any interest. So once the house is sold under foreclosure, and it will be a foreclosure auction, which means if, regardless of what the house is worth, they might not get close to that. Now, during the raid in the house a couple of years ago, we have seen the body cam photos of that. And the Owens has not done anything to that property except some landscaping since they moved in, which is a number of years ago. So whoever buys that house has to clean it out, assess the damages. If I would give an estimate, maybe 1.2, which means $1.1 million in debt or more.
Maybe have moved out the foreclosure date more, but we are certainly wanting to work behind, the scenes out, I guess, outside of bankruptcy court with them to resolve this.
Okay. Well, very good. I wish you good luck in that regard.
Thank you. And thank you again for your recommendation on going through the mediation program in the court. We really wanted to work with that, but it just looks like...
Don't suck up. I mean, brown-nosing this judge, I don't think will do any good. But it looks bad.
That ends when the bankruptcy would be dismissed.
All right. What else do you want to tell me?
That's how interested the judge
just
was.
That I think regarding the GoFundMe campaign, we wanted to stress that there were no promises that were ever made to the donors, and that this was an effort that was the culmination of my husband's 5 decades on the air, and he and our family were very, very deeply touched by the outpouring of support from his listeners.
Yeah. This GoFundMe, which is still live, by the way, and it's close to I think it's over $137,000 now. I would say it's a scam, because actual medical bills, $243, then other things related to his illness. I believe the number was around 40,000. Which means that out of $137,000, only 40 of them went to the suggested cause, which was Ronn Owens and his medical bills and medical needs. It's vile. And I can assure you, once this is dismissed, they will make a push again to get money through that. And from knowing statistically that most people who support these GoFundMes are not wealthy. Usually there are people who are or have been in similar alleged situations, like medical bills and stuff, which they have pulled themselves out of, and now they, I can donate $5 a month to this, to Ronn Owens, my childhood hero on the radio, and it's vile, absolutely vile.
Who have truly become like an extended family to us over the last decade. So this was an appeal that was needed for housing and food and transportation and those kinds of things. And we were just very, very grateful for those contributions.
All right. Thank you. Anything further?
Not for me.
Okay. Mr. Owens, did you say something, sir?
No, I said not off the top of my head.
Okay. All right. Thank you. Let me turn back to Ms. Giaimo. Anything further, ma'am?
No, Your Honor, I don't think it's necessary for the U.S. trustee to get into a back and forth with the Owens about the GoFundMe funds. Our pleadings speak for themselves, and it's not an issue that is going to be resolved here in any event. So we'll just leave it at that.
Okay. Let me ask you this. With respect to a dismissal, is the court's signed minute entry sufficient, or will your office wish to upload a formal order?
I think the court's minute entry would be fine. I don't want to have to deal with having to go back and forth and try to make sure that we're on the same page. I mean, especially because we have Ms. Naylor and Mr. Owens here on the record. You're seeing them here, I'm seeing them here, and it's clear that they're voluntarily agreeing to this. I would be comfortable with a minute entry of dismissal saying that there's it's a 2-year bar to refiling. Although I guess I wonder if we do need an order on the record so that if another case is filed, there's something more clear on the record.
The clerk's office should be able to pick up from the minute entry what we call an exception. And so it would be noted so that if another case is filed, it would trigger personal or direct review. Let me check with Ms. Hall and make sure I'm not mistaken in my understanding, but I think that's accurate.
Judge, and it would be in the ordering paragraph as well.
Okay. Right. So the minute entry will suffice for a bar date.
Perfect.
Okay.
That works.
So nothing else. And so Ms. Naylor and Mr. Owens, just so you're clear, I was just asking Ms. Giaimo about the form of order that the court will issue. Generally, we issue a minute entry after every hearing, and I'm happy to sign that minute entry, and that will be the formal order of dismissal, and I was asking whether Ms. Giaimo's office would prefer to have a specific form of order of dismissal. She's concluded, and I agree that that's not necessary. I'm just giving you.
This is an interesting question from Ree. After the life insurance policy being paid, I have a question on how debts can be collected. I honestly don't know if a life insurance payout is available for creditors. I honestly don't know the laws and regulations regarding that. Me personally, go get it. Absolutely go get it. But I don't know. I really don't know.
The courtesy of asking whether for some reason you would like that.
No.
Okay. All right, then. I'm prepared to make a ruling. Thank you, everyone. All right. So the matter before the court today is the debtor's motion to dismiss their voluntary Chapter 11 case. The debtors filed this motion, and afterward, the debtors and the United States Trustee's Office have come to an agreement for dismissal of this case with prejudice, and they have agreed to dismiss with prejudice with a bar to refiling this case or any bankruptcy case for a period of 2 years. I've reviewed the motion. I've considered the parties' stipulation, the record in this case, and whatever arguments have been made by the parties. The court does find and conclude that cause exists under the United States Bankruptcy Code, Section 1112B, to dismiss this case. The record does demonstrate that the debtors have been unable to satisfy the obligations imposed under Chapter 11 and upon Chapter 11 debtors. And it's also clear that there's no reasonable likelihood that this case can proceed to a successful reorganization within a reasonable period of time. The court further finds that dismissal, rather than conversion, is in the best interest of the creditors and the estate. I've considered the scope and the nature of assets and the potential for transfers that could be avoided or other claims, and it appears that that would be very difficult and costly for any Chapter 7 trustee to undertake. The remaining question is the scope of any prejudice to refiling. Although the parties have stipulated to a 2-year refiling bar, I believe it's incumbent upon the court to independently determine whether that requested relief is warranted under the Bankruptcy Code and the facts of the case. In particular, since we haven't had an evidentiary hearing. A dismissal with prejudice and a prohibition on refiling constitute extraordinary relief. And generally, the court's rule is that such a bar should extend no further than necessary to address the conduct that has been presented to the court. So again, I do find that cause exists to impose a refiling bar. The record reflects significant failures to comply with the requirements of Chapter 11 and demonstrates that dismissal without prejudice would not adequately protect the integrity of the bankruptcy process. Accordingly, a period during which debtors may not seek relief in bankruptcy is appropriate. The court is also persuaded by the multiple errors, the misstatements, and even possible misrepresentations that the present record does justify a 2-year prohibition on refiling. The court concludes that a 2-year bar will accomplish the purposes of 11 U.S.C. Section 104.
Yeah, and not only a 2-year ban of refiling, they are banned from refiling in any federal bankruptcy court. They just can't cross state border and file a new bankruptcy in a neighboring state's federal bankruptcy court. This will be shown on the documents as well. They are banned from seeking bankruptcy in the entirety of the United States.
5A and 349A. A 2-year refiling bar adequately protects the bankruptcy process, discourages abusive or premature refilings, and is appropriately tailored to the circumstances of this case. In particular, because the debtors have consented to that 2-year bar, and Ms. Giaimo points out an unusual and perhaps novel consideration the court had not previously considered, which is that with more time provided to the mortgage company, perhaps the parties can enter into an agreement or arrangement that meets all the parties' needs with respect to the real property. So for these reasons, the debtor's motion to dismiss is granted. This Chapter 11 case is dismissed under 11 U.S.C. Section 1112B. The dismissal is with prejudice to the filing of any bankruptcy petition by either debtor under any chapter of the Bankruptcy Code for a period of 2 years from the date of the entry of the dismissal order, which shall be the minute entry that will emanate from this hearing. I'm not expecting any additional form of order. Rather, as soon as this minute entry is filed, the case will be dismissed, and that will be the end of the matter. And with that, I believe everything that we were here for today has been considered and concluded. Is there anything else we need to discuss, Mr. Owens and Ms. Naylor?
Nothing.
No, just thank you very much for allowing us to appear via Zoom with the heat today. It's a lot more comfortable for my husband and for me. So thank you.
All right. Well, you're welcome and good luck. Ms. Giaimo, anything further, ma'am?
Nothing further from the U.S. trustee. Thank you very much, Your Honor.
All right. With that, then we are adjourned. Thank you, everyone. Good luck.
Thank you.
Yeah, so, folks, this now means that this case in the whole Owens saga is temporary over, at least for the next 2 years. Now, are there any risks in here? Are there any ways for them to sneak into bankruptcy court again to stop a foreclosure? And I believe the only thing they have as an option, which I certainly don't recommend because it would put Sarah Owens into trouble. That is, I believe, since Sarah Owens was a co-signee of that remortgage, she potentially can ask to put them into bankruptcy. I know it's a possibility over here that a person who is a co-debtor can ask for the other debtors to put them in bankruptcy, and that is to protect their resources and their assets. So that might be a possibility, but that would take Jan and Ron Owens to manipulate their other daughter into joining this scam. And I have to say, do not underestimate bad faith actors, bad parents like these two to try to manipulate their innocent daughter, luring her into this. I wouldn't take it out of the realms of possibilities. It's horrendous, but it might happen. You never know. You never know with these scammers. You never know what they are prepared to do. But this also, if the foreclosure goes through, the house is auctioned off, which means Laura Owens will not have a home. The now 36-year-old, I believe, woman who has never had a job, according to her bankruptcy filing, but according to her criminal defense attorney, had a job with a steady income before 2025, which makes no sense. She has to get a job, which actually might be a bond condition. Or if at trial she is to be sentenced to probation, it might be a probation condition that she go get a job. Which, in Laura Owens' case, she will feel that any type of job will be beneath her. Here's the thing, court doesn't care, especially when you are a serial pregnancy scammer like Laura Owens. And regarding the Laura Owens case, a couple of weeks ago was the final trial management conference. Now, the Laura Owens trial will be postponed a bit because still in plea negotiations, it seems. Now, I don't think Laura Owens will ever take a plea deal admitting, being forced to admit that she is a scammer, a fraudster. I think she will go to trial. But let's listen to the latest hearing. Oh, and thank you, South Florida, for 200 euros. Yeah, let's go through these. Thank you, South Florida. Thank you to Mama Big and the Great Paw. Yeah, those were the three latest. Yeah, you can support this channel if you are on mobile via the Jules system, which I am, let's just say, I don't know what they are worth in a monetary setting. All I know is this amount of Jules I didn't have before this stream started, which means you support me and this channel. So thank you very much. So let's listen to this. It's not a long it's not a long hearing.
Schnitzel Ninja.
This is CR 2025-007905, State versus Laura Michelle Owens. Time set for a final trial management conference. Can I get appearances, please? Good morning.
Christian Reed, on behalf of Ms. Owens, is present with me at the podium.
Ms. Owens, can I get your name and date of birth, please?
Laura Michelle Owens, 5/14/1990.
Oh, yeah,
What are you
she's
doing today?
36.
Your Honor, I filed a motion to continue over the weekend, asking for the FTMC and trial date to be continued 90 days and asking the court to schedule a settlement conference in the matter. We discussed that at the previous CCMC, and I'm hoping the court still has availability on August 28th. But
Yep, I got that booked. Mr. Leiter, does the state have a position on the request?
No, in line with the settlement conference, we hope to resolve the case. That makes the most sense to me.
All right, Ms. Owens, you're good with the continuance? All right, I'll find extraordinary circumstances, grant the motion to continue. If we could reset this about 90 days, please.
Trial date would be October 28th, 9 a.m., FTMC October 21st, date 25.
How is October 21st and October 28th?
Works for defense.
That's fine.
All right, Ms. Owens, you need to be in my courtroom on August 28th at 2:30 for a settlement conference. Then you have a FTMC October 21st, 8:45 before me. Trial assignments October 28th at 9 o'clock before the trial assignment judge. If you fail to appear, warrant will issue for your arrest. If you don't show up for trial, could occur in your absence. Stay in touch with your lawyer. New last day.
November 28th.
Anything else you need to talk about today?
What was the time on August 28th, Your Honor?
9 o'clock, standard trial assignment time.
No, I'm sorry, for the settlement.
Oh, that is at 2:30 p.m., August 28th.
Thank you, Your Honor.
Gotcha. Thank you. We're in recess in this matter.
Yeah, this type of is just doing update. Short update. Here's the new dates. So yeah, they are postponing things a bit. The state hopes to resolve this in a settlement, also known as a plea deal. I doubt Laura Owens will plead out, because that would make her admitting she is a fraud, a scammer, and everything in between. But she pushes it forward. And why is that? Well, because she's currently in another litigation. She's appealing the court's decision in California to dismiss her restraining order thing that she has against Mike Maricini. Now, she knows the moment she pleads out, the moment she is convicted, she has nothing to go for, because then she is a convicted felon, convicted of scamming, altering evidence, identity theft, which is in the California matter. It's the same type of thing as she did against Clayton Eckert and Greg Gillespie, but it is 11 years ago now against Mike Maricini. He didn't want to be with her anymore, so she faked pregnancy. She faked terminating that pregnancy. I mean, the case is abnormal. And Laura Owens has been getting away with it, using the court systems for over a decade. But finally, we are looking at maybe the end of this saga there as well. So August 28th, which is 20 days from now. And then we have to wait and see. Will she take a plea? I don't think so. It would be in her best interest, but I don't think so. All right, folks. Now you've been updated on that as well. Which means this is the end of the show. I thought I saw Mr. Jingles. Ah, folks. Ah. Look. Mr. Jingles is here. So, folks, from me and Mr. Jingles, thank you. Thank you for allowing me to do this. Thank you for showing up at my live streams and watching my videos. And thank you so much for the jewels. Thank you. Yeah, that's what I had for you for today. Thank you so much. Oh, thank you to Ponscom Posse for 20 euros. Thank you, thank you, thank you. You all have a good one. And I don't know if I'm doing a video or stream tomorrow, but at 6 p.m. today, I have a video release. It is about the JLR situation, the TED incident, and the alleged self-ending attempt, and how he is trying to blame Hella for that. I will give you my honest opinion. The video release is 6 p.m. Eastern Time. So keep a lookout. Thank you to Lori. Thank you, Lori. Thank you, Lori. Thank you, everybody, for the extra jewels. Thank you so much. You all have a good one. and I will see you all in the next stream or video. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus.